has a number of historic ordinances dating back to 1959, ordinance enacted in 1959, ordinance enacted in 1971, 1984, and 2002 that do a variety of, that are a variety of kind of the normal kinds of conduct ordinances that a municipality will have. And tonight we're primarily looking at three ordinances, at three provisions of some ordinances. One of which is in Chapter 6, Part 2 of the borough's Code of Ordinances, dealing with, that section deals with firearms. Another section is in Chapter 16, Parks and Recreation, which regulates broadly the conduct in park and recreation areas. And the final one is in Chapter 6, Part 3, dealing with conduct in public parking lots. So these are generally applicable ordinances that have been long on the books. There is a section of the of state law called the Uniform Firearms Act. And the Uniform Firearms Act, bear with me a second. The Uniform Firearms Act, among other things, provides, as a general rule, that no county, municipality, or township may in any manner regulate the lawful ownership, possession, transfer, or transportation of firearms, ammunition, ammunition components, when carried or transported for purposes not prohibited by the laws of the Commonwealth. In the last legislative session, the legislature passed what's now known as Act 192 of 2014. And Act 192 doesn't change that provision of the Uniform Firearms Act. Act 192 dealt with two different topics. It dealt with regulations concerning the theft of metals, and then there was a section added to it that added elements to the Uniform Firearms Act. And what it did was it broadened the scope of legal standing. Standing is a legal principle that governs who can bring a legal claim, who's got the lawful ability to bring a legal claim. And as a general rule in the law, you have to be somebody who's been injured. If you want to challenge an ordinance, you want to challenge a law, you have to show that you'd be impacted by that. And then in the normal course, when you're challenging a municipal ordinance, you generally have to show that you're within the zone of people who would be impacted by that ordinance within that municipality. What this law did was broaden standing. So in effect, anyone in the state or an organization that's concerned with the rights of firearm owners would have standing to challenge the lawfulness of borough ordinances. I'm speaking in generalities, just to provide the context. Another thing that the law did was it did what we call fee shifting, and it said that if somebody challenges a local ordinance as violating the Uniform Firearms Act, that and that ordinance is declared illegal, that the municipality is responsible for the attorney's fees of the person or organization who brought the challenge. If the organization sues the municipality and the municipality then repeals their ordinance, under Act 192 as it is written, the municipality would still be responsible for those attorney's fees even if they repeal the ordinance after the challenge. And a number of municipalities, and this came about, as I understand it, in response to municipalities that had, in more recent years, enacted ordinances relating to the transfer of firearms, that there had been an increase in that kind of activity from some municipalities. And this was done in large part to what I think was perceived by the legislature as an increase in local efforts to regulate the lawful possession of firearms. Because the Act 192 contained these two different provisions, some of the municipalities that were unhappy with the law have filed a constitutional challenge to Act 192. And they did it under a section of the Pennsylvania Constitution which I was right around with me. You laugh, but it's true.
It's true.
Article 3, Section Article 3, Section 3, which says that no bill shall be passed containing more than one subject, which shall be clearly expressed in its title, except for a general appropriations bill or a bill codifying or compiling the law or part of thereof. So the principal challenge to 192 is that it violates that provision of the state constitution, because the argument is it violates what's called the single subject rule. It has these two unrelated subjects. That's working its way through the courts, and we don't have an answer for that. The borough received a memo from the Delaware Valley Insurance Trust, which is effectively the borough's insurance provider, risk management entity, that identified these issues for the borough, and not just for this borough, but sent it out to each of its members, and recommended that the borough consider the risks associated with whatever existing firearms ordinances, all the boroughs consider whatever, and other townships, consider the risks and consider repealing and suggesting repeal of those municipal firearms ordinances. And so we have drafted a proposed ordinance. We've done provided some language for the borough's consideration. Let me just, do you want me to go through what the specific ordinance language is that would be repealed if you approve this?
I think that would be worthwhile for everybody to do.
Sure. Okay. The first is I had identified Chapter 6, Part 2, firearms. That portion of the borough's ordinances has 4 sections. Sections 201, 202, 203, and 204. I'm going to try to avoid reading the whole thing, but I want to try to give you a sense on what they deal with. Section 201 is the principal section of concern, and it says, and this was enacted in 1959 and revised in 1984, except in necessary defense of person or property, and except as provided in Section 3 of this ordinance, and Section 3 deals with exceptions, which I'll get to in a moment. It shall be unlawful for any person to use, fire, or discharge any gun or other firearm within the borough of Doylestown. The exceptions to that are for persons licensed to hunt in the Commonwealth while actually engaged in hunting where it's permitted, members of any organization incorporated under state law engaged in target shooting upon the grounds or property belonging to or under the control of such an organization, and any law enforcement officers when used in the discharge of their official duties. So the concern for the borough is that the regulation in Section 201 that limits a person's ability to use, fire, or discharge a firearm that ordinance constitutes a regulation of the lawful ownership, possession, transfer, or transportation of firearms for purposes not prohibited under the law of the Commonwealth. And so the concern is that if that ordinance were challenged, that section of the ordinance were challenged, that the limitation on the use of a firearm, on the discharge of a firearm, would be considered a regulation of possession of a firearm, generally speaking. The other section of the borough's ordinance that, and I'll just say Section 202, we received a letter from an organization that is concerned about these issues. That organization also, and I am assuming there's a representative or representatives here tonight, that organization also identified Section 202 of the borough's ordinance, which on its face excludes regulation of firearms. And the law has a definition of firearms, and this Section 202 deals with air rifles, bows and arrows, and similar devices, which are excluded from the definition of firearms. So our proposed ordinance for your consideration tonight doesn't address section 202. The other section of the borough's, one of the other sections of the borough's ordinances that's implicated here is chapter 16, Parks and Recreation, conducts in park and recreation areas. And in particular, subpart 3 of that, and the whole of the statute says, the whole of the ordinance says no person in a park shall, and then lists a variety of things. And one of those is hunting and firearms. So no person in a park shall hunt, trap, or pursue wildlife at any time. No person shall use, carry, or possess firearms or any descriptions, of any descriptions, or air rifles, spring guns, bows and arrows, slings, or other forms of weapons potentially inimical to wildlife and dangerous to human safety, or any instrument that can be loaded with and fire blank cartridges of any kind of or any kind of trapping device. Shooting into park areas from beyond park boundaries is forbidden. And so the section of that deals with firearms is that no person shall use, carry, or possess firearms of any descriptions. Otherwise, you could strike that. Then the limitations on the use of air rifles, bows and arrows, and slings isn't impacted by the Uniform Firearms. There was a case that was brought within the last year where a ordinance that limited this kind of activity was challenged. The court struck down the ordinance, but the court, in doing so, had a footnote that noted that the municipality didn't defend on a basis that it might have defended on, which is that the municipality was otherwise empowered to enact regulations related to its parks, and so that issue hasn't been fully vetted by the courts. Certainly, Commonwealth Court in that footnote is signaling that it might be open to that defense, but that wasn't resolved. The final section is somewhat similar, but it relates to the public parking areas. And in section 304, this relates to prohibited conduct in public parking areas. It shall, subpart 9 of section 304, it shall be unlawful for any person to carry or discharge any firearms, slingshots, firecrackers, fireworks, or other devices upon any public parking lot which have such properties as to cause annoyance or injury to any person lawfully using such public parking lot, or injury to the property of such persons. So the concern is, again, because firearms are mentioned, that a claim could be made that it runs afoul of the Uniform Firearms Act. And so the draft repeal ordinance would strike the word firearms, so that it would be lawful under borough ordinance to carry firearms on a public parking lot so as to cause annoyance or injury. But it wouldn't be lawful to do that with a slingshot. The concern, obviously, is regardless of the merits of any legal claims, that there is a substantial financial risk to the borough, and that that risk is something that borough has to consider in considering what to do with the repeal. And I'd leave it to the chief to discuss the ability of the police department to protect public health, safety, and welfare under state law for those areas in which that repeal would happen under the borough's ordinance.
It would be, a borough is an urban environment as opposed to some rural, I'm sorry. A borough is an urban environment as opposed to some rural township. So the concern for the public welfare is that somebody discharging a weapon is bound to hit somebody or something. So I would be concerned that if the ordinance was repealed, that we wouldn't have a recourse, but we do have a recourse. The recourse is the state law. Risking your catastrophe, recklessly endangering, vandalism, all of those state laws come into effect, and we would charge with the state law before we would charge with a borough ordinance anyway. So the repeal of any of these ordinances, to me, doesn't seem very important because the state would cover that. People have a right to carry weapons, and the Constitution tells them that. You have to carry them openly, unless you have a license to carry and conceal. But you do need to have a license to carry to conceal. Open carry is fine. And I don't see this as impeding the health, welfare, or safety of the community, because the state has laws that we will enforce. Now, it would depend on the individual circumstances of the individual incident, what we charge, and we would go through the district attorney's office to do that. But there is a recourse here to arrest people that fire a firearm in Doylestown.